Having a felony conviction on your record can impact all kinds of rights, including, but not limited to, the loss of voting rights in some states, the loss of your Second Amendment rights, problem with housing, employment, getting student loans, and a whole host of other collateral consequences. So you can imagine how often we're asked at Scrofano Law PC whether you can get a felony conviction sealed or expunged in the District of Columbia. Unfortunately, we often have to tell folks that the answer is no. But in this video, we will explain one specific limited scenario where it is actually possible to get a felony conviction off your record in the District of Columbia. My name is Joseph Scrofano, and I'm the founder of Scrofano Law PC, where we represent individuals under an investigation or charged with a crime in the District of Columbia, Northern Virginia, and Maryland. In this week's video, we dive into the intricacies of the Youth Rehabilitation Act and how significant it is for individuals seeking to claim control over their lives, reclaim their civil rights, and help repair the damage that a felony conviction may have caused. Now, for decades, it's been virtually impossible to get a felony conviction off of someone's record in the District of Columbia. However, recent years have seen the City Council take some small steps for certain individuals to help rebuild their lives and to do exactly that. Now, it still has limitations and is not available for everyone. However, one such avenue is the Youth Rehabilitation Act, which was amended in 2018 and provided substantial steps for youth offenders in D.C. to get their convictions set aside and potentially sealed in some cases. Now, I say it was amended because for years, the D.C. Youth Act existed and was only available to individuals convicted of a crime that occurred prior to them turning 22 years old. The then existing YRA, as it's called, did provide some relief as long as you were under 22 at the time of the offense and the judge agreed at the time of your sentencing to sentence you under the Youth Act. However, the 2018 amendment made two crucial changes that fundamentally changed the law for the better. First, it amended the age to being under 25 at the time of the offense. Second, it allowed the statute to be applied retroactively. That means anyone who had been previously convicted, even decades ago, could go back and petition the court to set aside their convictions under the new YRA. However, it's crucial to differentiate between setting aside a conviction and sealing the records. Even with the conviction set aside under the Youth Rehabilitation Act, there are still several implications to consider. The conviction may still be considered for sentencing enhancements in the case of subsequent offenses. And it can be considered in various circumstances, including having to register as a sex offender or as a gun offender. In addition, a judge can still consider a set-aside conviction at sentencing in any future conviction and can also be used for impeachment purposes if an individual is testifying at trial during cross-examination. Who qualifies under the Youth Rehabilitation Act? In short, it's individuals who were under the age of 25 at the time of the offense. Now, the Act's retroactive application extends this eligibility to those who are no longer under 25, but were considered youthful offenders at the time. That means someone convicted of a drug felony or otherwise, even going back to the 80s, can now come forward and petition the court to set aside their felony conviction. For certain serious offenses, however, such as murder and felony sex abuse, they are not eligible under the Youth Act. Now, it's important to note that being eligible does not guarantee a judge will grant the motion. So, what factors does a judge consider when deciding whether to set aside a conviction under the YRA? These factors are set out in the statute and include the age at the time of the offense. Now, courts tend to be more lenient on younger offenders. The nature of the offense. This means any prior sentencing the movement previously received under the YRA. Some judges may not look favorably upon giving someone a second sentence under the YRA. The courts look at compliance with facility rules. If the movement did time, how was their disciplinary history in the prison or jail facility they were at? Their participation in rehabilitative programs. These would include things like completing drug, mental health, or anger management treatment. The courts will consider previous contacts with the justice system, including a juvenile record. The courts will consider family and community circumstances at the time of the offense. the ability to appreciate the risks and consequences of their conduct, and any reports of physical, mental, or psychiatric examinations, and finally, the movement's capacity for rehabilitation. Now, while there's no formula and no one factor that is determinative, presenting a strong case based on these factors can significantly increase the chances of having a conviction set aside. And hiring a qualified DC criminal defense attorney can help you put together the strongest petition possible. The last thing I want to mention is that the City Council went even further and passed a more progressive record sealing act back in 2022 called the Second Chance Amendment Act that would permit expungement of certain felony convictions under certain circumstances, and would also, among other things, provide automatic expungements for certain arrests that result in dismissals. However, the law has not been funded, and there's really no information out there about when it will be funded and when it will actually go into effect. So, in conclusion, the Youth Rehabilitation Act can serve as a pivotal tool for restoring rights and providing a second chances and providing a second chance to those who qualify, and is currently the only possible limited option for someone to get a DC felony conviction taken off their record. Finally, for many old convictions that get set aside under the YRA, once the conviction is set aside, the movement may be eligible to have their record sealed under the Record Sealing Act, which is something we've discussed in a previous video. You can click on here to learn more about the DC's existing Record Sealing Act. Now, if you, a friend, or a loved one has been plagued by a DC felony conviction and were under 25 at the time of the offense, contact us today for a consultation. Or if you like this video, please consider giving us a thumbs up and subscribing to our channel to learn more about legal topics and issues in the District of Columbia, Maryland, and Virginia.